It's really important to really think about where these laws came from and why they exist. At least I think it's important, just to have a context of, how all of this started. And the way I think of it is that the laws are based on occupancy. When you occupy space, then you become the owner. That is how property started from the beginning of time, because we were just roaming around on the planet, and then someone said, hey, I'm going to plant some crops here and stay here. They occupied that land, and then that became their land. Well, in the US, occupancy is two different things. When poor people, indigenous people, or people that have basically no power in our system occupy land, it's called squatting. And I squat. I take that as a badge of honor, and I think it's a positive thing. Of course, in our society, people in power think differently. When those in power, those that are wealthy, those that conquered this land, occupy land, that's called manifest destiny. And they're the ones that wrote the laws. And so they wrote laws that are actually very pro-squatter, because it was them. They're the ones that squatted native land, so they wrote laws that justified it. So those laws are still on the books. The laws from the inception of the state of California, and the laws start with how you acquire property. Property in California is acquired through 5 different modalities, 5 different means, and occupancy is the first one, because the guys who wrote the law were just pretty much taking whatever they could. And so occupancy is the first, it's one of 5. The other is transfer, when someone buys or sells land. The other is will, when someone dies and leaves it to their heirs. The other is succession, when someone dies, doesn't leave it to the heirs, but their heirs get it anyways through intestate succession. And then a weird thing called accession, which I think is a volcano erupts in an island and you're on it and it gets bigger, and then something like that, I don't know. But it's not important. What is important is that occupancy is the first mode of acquiring property. And a code section that I've fallen in love with, which I know is perverse, is Civil Code Section 1006. People, I guess, in power forgot to delete this from the code sections, but Civil Code Section 1006. Oh, and I should mention that Terry Don here has these small little flyers that basically have everything I'm going to cover. So if you don't have one of those and you want to know the law, I've pretty much put it all down there. And it's a lot of code sections, so you're going to have to use it as a way to do your own research, because I didn't have enough space to put all the explanations. But Civil Code Section 1006 states occupancy for any period confers a title sufficient against all except the state and those who have title by prescription, accession, transfer, will, or succession, the other modalities of acquiring property. But that title conferred by occupancy is not sufficient interest in real property to enable the occupant or the occupant's privies to commence or maintain an action to quiet title unless the occupancy has ripened into title by prescription. And so basically the clincher is the first line. Occupancy for any period confers a title sufficient against all except the state or the previous owner if the previous owner shows up. So basically, you occupy a space and no one comes forward and says, hey, I own this place, get out, then it's yours. No neighbor, no police force, no city official can come in and remove you from that property. Well, at least according to this law. I don't know what really happens in real life. We've seen different things with Occupy Oakland, but so yeah, it's yours until someone comes forth and they have to prove that they have one of those titles that's listed. And they have to say, oh, I inherited it from my great aunt, or I bought this from the guy, 20 years ago, or something. They have to prove they have a superior title. And so this is really just an interim title by a squatter, and it's something you can use to say, hey, quit harassing me. I own the house. And then if someone that doesn't own the house is harassing you, you say, well, you don't own it, and I'm in possession. Going back to Roman times, possession is 9 points of the law. So, at any rate, the next phase of this is called adverse possession, and this is another concept that squatters that have been around for a while are completely obsessed with. It's the holy grail of squatting, and adverse possession is defined by the next code sections, section 1007 in the Civil Code, but more clearly defined in the Code of Civil Procedure, and basically in its Civil Procedure section 325, and what it is basically, just to lay it out, is if you occupy land for 5 years without the permission of the owner and you pay the taxes during that time, it's yours for good, forever. It extinguishes all previous titles, and anyone who comes forward trying to oust you from the land after that 5-year period cannot do so. Of course, you have to prove that you've been there for 5 years. You have to prove that you have paid all those taxes, and the burden's on you once they come forward and say, hey, I owned this 10 years ago and I just, did whatever. And so, and something interesting is that during the period of time that you're on the property, there is a revenue and taxation code called section 610, and I know code sections are really, everyone loves them, but it says that if you go down to the county assessor's office and write a declaration under penalty of perjury, then the assessor has to assess the property in your name and add your name to the assessment rolls as the owner of that property. And that's Revenue and Taxation Code section 610. And this is where things get weird with the law. And you realize that the law is really, in practice, not something that people really care about that are in power. Because I've gone down to the assessor's office, asked them, hey, I want to be put on the assessor roll. I declare under penalty of perjury, section 610 of the Revenue and Taxation Code. And they said, oh, we don't do that. So, just to let you know, give you some idea of how these laws work, which is they don't. If you're occupying land, you have all these rights, and it has to be the owner. They have to file. They have to prove they own it. They have to take you to court. They have to do a quiet title action and all this stuff on paper. But really, the fact of the matter is, the cops come in, they kick down your door, they drag you off, and they put you in jail. And that is where we have the interesting next counter thing. So we've just talked about right now, what I've just laid out for you is all the rights you have, all the property rights you have as an occupier, as a squatter. Those are your rights, and they sound really nice if you're looking at the Civil Code, the Taxation Code, and the Code of Civil Procedure. But there's also the Penal Code. And I have to switch pages because the Penal Code, unlike the concise Civil Code that is one sentence, we have a Penal Code, section 602 and 602.5, which some of you might be familiar with by now after occupying some properties, and maybe some of you tore down some of the signs and have them at home as a souvenir saying, entry is violation of Penal Code section 602. Penal Code section 602, subdivision A, C, D, E, G, F through X or something. Basically, the way I look at Penal Code section 602, it's like if you look the wrong way at a piece of property, you're going to jail. It's if you enter property that has a fence, it's against the law. If you enter property without a fence, it's against the law. If you enter a property that has signs, it's against the law. If you take signs down, it's against the law. If you take a sign down in public, it's against the law. If you take a sign in private property, it's against the law, and so on and so forth. It just goes on, and some of the subsections are just ridiculous. It's about, 2-3 pages long, and it just goes on and on. And this is the weapon that the police use and the district attorney uses is Penal Code section 602. I was prosecuted under 602.0 and I got out from under that, and 602.5, which 602.5 is a little bit more reasonable. It says you can't enter someone else's residence. Okay, that makes sense, but an open field with a cow on it and you're standing there. And it should be noted historically that the laws of occupancy have existed since the beginning of civilization. The laws of criminal trespass have not. And I don't know when criminal trespass was enacted in the US, but I know in England that the concept of criminal trespass did not even exist until the 1980s. So this is actually a new concept of criminalizing people who are in the commons, you know, people that are on land that's not being used. Because the concept historically is really counterintuitive, because if land is unused as a civilization that relies on agriculture and has lots of people, you know, you want to use it and utilize land. And what criminal trespass is doing is to create a context in which, at least I believe, and some of the case law supports this, is a way to basically suppress dissent and oppress. And that is where we start getting into defenses, because really, when you have the laws of occupancy that say, yeah, you occupy something, you're the owner. And then you have another law that says if you enter any piece of property, you're a criminal. So you have right now a dissonance in the law where it's two contradictory legal theories. One saying, hey, if it's not being used, you should take it for the benefit of society. And the other one saying, hey, if you're some poor person or some person we don't like and you enter property that's not being used, we're going to put you in jail. So in theory, you could actually enter property, occupy it for 5 years, go to jail numerous times, reoccupy that property when you get out of jail, and then be the owner by adverse possession, but then have a criminal record and for acquiring the land that you once owned. And then, so this actually happens, these kind of things. People getting convicted. For example, People v. Lepczewski is a case where a guy was collecting rent, and they said, well, you were squatting the property fair and square, so you get to keep the rent, but you had to pay the mortgage payments. And so just we get these weird legal conundrums. But there are some defenses that show how ridiculous this is. Well, first of all, there's the one-off defense of mistake of fact. If the cops show up and say, hey, you're not supposed to be here, then you could say, well, I didn't know that. And so then you can leave. And then usually you have to go back a second time. So usually you can get off on that one time. So if the police arrest you and you go into court and say, I didn't know that I wasn't allowed to be there, you know, it's hard to really prosecute that. In general, but not in California, you can say, well, it was abandoned, so I was just occupying abandoned land. In California, supposedly, the prosecution has to prove that it was abandoned to get you convicted, but I found out the hard way that that's not necessarily the case. So there's also the Fourth Amendment defense, which is due process. You can argue that if you are in possession of the property, this only really works if you've been in possession for a while. I mean, in practice, it only works if you've been in possession for a while, where it looks like, okay, you've established yourself, you have some mail, you have some utilities are on, and then the owner calls the police and says, hey, take these people off my property. Well, you can argue that it's an illegal eviction, that since you're living there and it's your home, your residence, that they are basically required to go through a proper eviction proceeding. And the case on that is on the piece of paper, which is going around. If you don't have it, you should probably raise your hand. But it's King v. Massaraway, and it's on that piece of paper, where an owner of property called the police, said, these guys are in my house and they're trespassing. The police arrested them. The police got sued. The police lost because the court said, well, we couldn't tell if these were tenants or squatters or who they were, and you needed to evict them through the civil process. And so advocates of squatting rights will always say it's a civil matter, it's a civil issue. The people that want to go after squatters will say, oh, these are criminals, and that's going to be always the conundrum where everybody's going in that route. The other thing that people have been arguing recently is the Eighth Amendment, and the Eighth Amendment basically bars cruel and unusual punishment. There was a case in Los Angeles on Skid Row where people were being rousted from their sleep and put in jail or removed and whatever. And the police were sued. The city was sued, and they said, you can't do this. Unfortunately, there's no case precedent because the lawyers worked out a deal with the city that would allow the people that were homeless to stay there as long as they didn't make it a new law that allowed homeless people to sleep in public. And so other people that are fighting sit-lie laws are kind of twisting in the wind, especially Santa Cruz or, it's kind of happening all over where they're making it illegal to sit or lie in public. And so, but there is a precedent, and I don't know if you guys have heard of Take Back the Land out of Miami, but they're a squatter advocacy group out there. Well, there is Pottinger v. City of Miami, which basically lays that out. It says if you're in Florida or if you're in the that district, that it is cruel and unusual to take away something that is necessary, which is a place to sleep and a place to seek shelter. And that's cruel and unusual punishment. And you cannot remove an encampment unless you provide alternate housing or an alternate encampment. And so the city of Miami right now has to follow that rule. And as does the city of Los Angeles, but the rule in Los Angeles doesn't apply anywhere else, whereas the city of Miami's rule applies throughout Florida. So that is something that's emerging. It's something that's new, and I think it's really relevant, especially when we saw the occupation at 18th, where they had permission from the owner and the neighbor, and the police